When it comes to the public health in the low and middle income countries, IPR become a double-edged sword. Let me explain how. The patent on life-saving medicines can make them extremely expensive, limiting access for the poor and vulnerable. During the HIV and AIDS crisis in the early 2000s, the antiretroviral drugs were priced far beyond the reach of money in Africa and Asia. And thousands of people died not because the treatment were not existed, but it was not afforded for them. It was due to the protection of the patent. Similarly, during the COVID pandemic, vaccines patent became a global issue, while developing states was struggling, and the developed states secured their dozens of it. In addition to this, we need to understand that the government of India in October 2020 has put a proposal along with the South Africa and Brazil to waive certain IPR provisions to make sure that the wider and faster access to the COVID vaccine treatment and diagnostics and related technologies are available. For example, in the case of Afghanistan, India donated 5,100 COVID vaccine doses to Afghanistan. If these medicines were not reached there, there would have been a chance half of the population would have died due to the COVID. Of course, we must acknowledge the role of IPR in encouraging pharmaceutical innovations. However, developing new drugs takes years and it requires millions of dollars. Without IPR, the companies may hesitate to develop new medicines to save lives. Indeed, the world has come to recognize that intellectual property law is not merely a technical legal norm, but one that sits the very intersections of ethics, economics, human rights, and the global justice. As we reflect on the challenges of the 21st century, we are reminded by the inadequate vaccine distributions, rising of the cost of biologics, and also entrenchment of the patent monopolies. This has deepened the urgency of the dialogues to deliberate the imperative to protect intellectual property and equally compelling obligation to uphold the public health in the global south, and where the access to life-saving medicines and technologies often remains elusive. We are particularly inspired by the judicial precedent that have asserted that the primacy of the public health in the international legal order. The Indian Supreme Court in landmark decision in the case of Novartis versus Union of India reminded us that national patent regime or the compliance with the TRIPS agreement must and it can be achieved with the constitutional values and the social realities. Similarly, the Constitutional Court of South Africa in seminal treatment action campaign case underscored that right to health is not an aspirational, but it is a necessity, and states bears a binding duty to secure for all its citizens. As such, this webinar is not merely an academic exercise. It is a forum for the critical engagement that seeks to examine the structural inequities embedded in the global IP regime. Our themes are compelling us to ask certain questions that can developing countries effectively asserts that their sovereign rights and the TRIPS agreement without fear of the TRIPS retaliation. Our current norms are aligned with the constitutional commitment to the health and human dignity. What reforms are needed to ensure that the rights of indigenous communities and values of the traditional systems are not overshadowed by market-driven patent regime? And finally, is it a time to envision a binding international legal instruments that guarantees equitable access to essential medicines as the global public good? These are not rhetorical and discussion, but these are challenges that to be discussed. And we are privileged to have eminent scholars with us to address throughout this webinar. To begin with, our webinar commences with the address of our chief guest, esteemed Professor T. Ramakrishna, former Professor of Law and former IP Chair of National Law School of India University, Bangalore. And we are honored to have with us Professor G.B. Reddy, as the guest of honor. Professor G.B. Reddy is the Honorable Vice Chancellor of NUYALS, and we are indeed privileged having with us keynote speaker, Professor Srinivaslu N.S., Professor of Law at National University of Juridical Science in UGS, Kolkata. And we are also pleased to have with us distinguished speakers, Professor Sanjit Kumar Chakraborty, to share his insight. And finally, we are privileged to have with us a distinguished speaker, Professor P. Siri Sudha, Dean and Professor of Law is RM School of Law, Chennai. And I would like to also recognize role of Professor M.S. Benjamin, Dean, Faculty of Law and Chairman, Department of Studies in Law and University of Mysore. At the final, I would like to also introduce Ms. Sarah Benjamin, who is going to introduce our esteemed dignitaries. At this juncture, I extend my deepest gratitude to all our speakers and the attendants. So to begin, I would like to request Professor M.S. Benjamin to welcome our esteemed speakers. Sir, over to you.
Thank you, Mr. Sayed Kasmi. Good afternoon, distinguished guest, Professor T. Ramakrishna, alma mater of the Department of Law, University of Mysore, Honorable Vice Chancellor, Professor G.B. Reddy, Professor Srinivaslu N.S., who is also alma mater of the Department of Law, University of Mysore, Professor Sanjit Kumar Chakraborty, Professor Sri Sudha, respected faculty members, esteemed scholars, practitioners, dear participants, and ladies and gentlemen. It is my privilege and honor to welcome you all to this important webinar on intellectual property rights and public health in developing countries, organized by the Department of Law, University of Mysore, Mysore, Karnataka. The mutual interaction between intellectual property and public health is one of the most debated and dynamic issues in the contemporary world. On the one hand, intellectual property promotes innovation, encourages research, development of new drugs, medicines, vaccines, and health technologies. On the other hand, public health focuses on accessibility, availability, and affordability of a quality medicine to all, whether rich or poor. In order to ensure that essential medicines and medical products are affordable, easy to get, and widely available, the IP laws provide for compulsory license. Compulsory licensing plays a very important role in balancing the patent rights of the pharmaceutical companies and public health needs. However, in developing countries, access to affordable healthcare to all often conflicts with the patent rights of the pharmaceutical companies. During the COVID-19 pandemic, India and South Africa requested WTO to temporarily remove certain patent rules for COVID-related products like vaccines and treatment. Thailand and Brazil used compulsory license for AIDS drugs to curb the AIDS epidemic. However, granting of a compulsory license faces some challenges in developing countries, such as pharmaceutical lobbies, limited use due to diplomatic and trade effects, legal hurdles, including litigation by patent holders. This webinar will provide us an opportunity to debate how the TRIPS agreement, the Doha Declaration, and national IPR laws interact with the public health priorities in developing countries. On behalf of the Department of Law, University of Mysore, I extend a warm welcome to Chief Guest, Professor Dr. T. Ramakrishna Sir, former IPR Chair Professor, PG Council Chairman, National School of India University, Bengaluru. To guest of honor, Professor Dr. G.B. Reddy, Honorable Vice Chancellor, National University of Advanced Legal Studies, Kochi, Kerala. Keynote speaker, Professor Dr. Srinivasulu NS, National University of Juridical Sciences, Kolkata, West Bengal. To distinguished speakers, Professor Dr. Sanjeet Kumar Chakravarti, Director, Center for Law and Social Justice, National University of Juridical Sciences, Kolkata, West Bengal. Professor Dr. Sri Sudha, Professor and Dean, SRM School of Law, Chennai, Tamil Nadu. I also welcome all participants, members of the organizing committee, coordinator, Mr. Syed Kudrat Asmi. Thank you, and I wish this webinar will be thought-provoking and fruitful.
Thank you, sir. Now, it is my privilege to invite Professor T. Ramakrishna, sir, to the virtual stage. Before we proceed, I would like to request my colleague, Ms. Sarah Benjamin, to introduce sir. Then we shall hear from sir. Over to you, Ms. Sarah.
It is my privilege to introduce our chief guest, Professor Dr. T. Ramakrishna, former Professor of Law and former IPR Chair Professor at National Law School of India University, Bengaluru. Professor Ramakrishna has been on the National Law School of India University's faculty since 2002 and has served as the MHRD Chair Professor in Intellectual Property Rights, heading the Center for Intellectual Property Rights Research and Advocacy at the university. His academic journey includes degrees in life sciences, LLB, LLM in international law and jurisprudence, an MA in political science and public administration, and a PhD in intellectual property rights from Mysore University. With a career spanning over 4 decades, Professor Ramakrishna has made significant contributions to the field of IPR law, covering copyrights, patents, trademarks, geographical indications, and the international IPR regime. He has played a pivotal role in policy and reform, serving on expert committees for the Indian Intellectual Property Office, National Biodiversity Authority, and Protection of Plant Varieties and Farmers' Rights Authority. Internationally recognized, he has contributed to major research projects, including on the globalization of biotechnology governance, traditional knowledge protection, and data protection training for industry. His work has also involved collaboration with international bodies such as WIPO and Field UK. Today, it is our honor to welcome a stalwart in intellectual property scholarship and institutional leadership. Please join me in extending a warm and respectful welcome to Professor Dr. T. Ramakrishna, sir. Thank you.
Sir, over to you. Yes.
Yeah, thank you very much. Am I audible?
Yes, sir, you're audible.
Okay. Thank you. Assuming that the Vice Chancellor is here, dear Professor Loknath, the Vice Chancellor of Institute of Mysore, Ms. Savita, the Registrar of Institute of Mysore, Professor Benjamin, Dean Faculty of Law, Professor G.B. Reddy, the Vice Chancellor of NUALS and my very good friend, Professor Srinivasulu, Professor Sri Sudha, Professor Sanjeet Kumar, Mr. Syed Kudrat Hashmi, Faculty of the Department of Law, Institute of Mysore, and my dear participants. Department of Law is my alma mater, where I studied LLM 48 years back with legal luminaries like Professor C.K. Raja, Professor Srinivasamurthy, Professor Devidas, Professor Nagaraj, imparting the rich culture to us and inculcating values in us. I had the opportunity of serving as a guest faculty for more than a decade in the department. I'm happy to be part of this international seminar on IPR and public health in developing countries organized by the Department of Law, Institute of Mysore. Let me at the outset thank Professor Benjamin, my good friend, the Dean, and the organizer, Mr. Hashmi. The topic identified is of utmost relevance in the context of access to medicines crisis, which is challenging the right to health. Health, as we know, is not just the absence of disease, but as enshrined in the WHO preamble, it's a state of complete physical, mental, and social well-being, and not merely the absence of disease or infirmity. Right to health is enshrined in the international instruments such as Article 55 of the United Nations Charter, Article 25 of the UDHR, Article 12 of the ICSCR, Article 6 of ICCPR, Common Article 3 of the Geneva Conventions, Article 10, 12, and 14 of the CEDA, and the General Comment number 14 of 2000. The right to health is also interpreted as part of the constitutional guarantee of right to life under Article 21 of the Indian Constitution. Several judicial pronouncements have affirmed the same. Goal 3 of the Sustainable Development Goal 2030, what is popularly called as SDG, aims to ensure healthy lives and promote well-being for all at all ages. Well, if right to health is a basic human right, then what is the objective of IPR? Whether it is also considered as a human right. In fact, Article 27, Para 2 of the UDHR states that everyone has the right to the protection of the moral and material interests resulting from the scientific, literary, or artistic production of which he is the author, thereby declaring it to be a human right. Though, of course, non-fundamental, which means it could be regulated by the state interference. We have similar provisions or assertions found in Article 1.1 of the UN Declaration on Right to Development, Article 19 of ICCPR, as well as Article 15 of the ICESCR. Well, having understood the right to health as a basic fundamental right, and even IPR as one of the human rights, let us see as to what is the objective of the patent. Generally, it is assumed that patent is the one which creates monopoly and is against the competition. But if someone looks at the foundational principles, for example, the US Constitution, Article 188 of the US Constitution, which ensures exclusive right to the inventor, that is not an end in itself, but it is with the objective of promoting the progress of science and useful arts, which is a larger public good. And similarly, if you look at the Justice Rajagopal Iyengar Committee report, which is the sequel to, or which is the beginning in the post-independence era of the patent system in India, it states, industrial progress of a country is stimulated or retarded by its patent system. Let us just start with a moot question: whether patent is a tool for progress of scientific innovation or not. Whether patent is a tool for progress of scientific innovation or not is a question that we're raising here. And you have equally strong arguments for the proposition as well as opposing this particular proposition that patent is a tool for progress of scientific innovations. If you look at the favorable arguments, you find that they bring in the element of incentive to invent. There must be an incentive to invent, and there is a temporary monopoly created which is going to confer certain rights on them, and through that, right, they would put in all the income back into the research, and then further innovation keeps happening, and therefore it fosters innovation. And in the field of pharmaceuticals especially, failures are more and success rate is limited. Under these circumstances, there must be some incentive for them to hold on to the investigation. Similarly, drug discovery is very, very, very difficult. Proponents to this particular argument, they also argued that TRIPS led to innovations by giving examples of more biopharma which started in the low and middle income countries after TRIPS, especially China, India, Brazil, they all started. Similarly, more healthcare institutions in the low and middle income countries started after TRIPS, such as clinics, hospitals, medical schools, funding, laboratory space, physician exchange, so on and so forth. At the same time, I told you there is an equally opposing argument which says innovation is a natural progress and is not motivated by the patent itself. There's a demand by the industry, by the people, by the society, which is the effective drivers and not the patent. Patent chills innovation or hinders innovation. And they look at patent as something which is a rent transfer from the people to the MNCs, resulting in exorbitant price. And it is not always given for the blockbuster invention, but for incremental innovations. However, you find in the pharmaceutical fields, although we keep calling India as pharmacy of the South, jointly US, EU, and Japan, they account for nearly 89.3% of the world pharmaceutical sales, which means developed countries' dominance is exhibited there. And if you look at the statistics of how pharmaceutical companies which have the patent protection, which will take IPR protection, have used IPR also as an effective business strategy in the market. Let me just point towards some of the business strategies followed by the pharmaceutical companies, either by use of patent or within the framework of this IPR. The offensive strategy that they adopt has been aggressive patent enforcement. Would not allow any individual or any company, any organization to even come near their innovations or their patented product, and they aggressively enforce their rights. They also go in for patent clusters or thickets, thereby putting a coverage on their product, both present as well as the future. And when they are threatened by the introduction of the generic manufacturer after the expiry of the patent period, they have also gone in for what popularly is called as reverse payments. They pay for the delay. It's called as also payment for delay. Let not the generic company enter into the market early so that this particular innovator drug would continue its dominance in the market. They also come out with something called as the new formulations. With the new formulations, they keep extending their portfolio. And there are certain circumstances where the pharmaceutical companies, as an offensive strategy, have also gone in for what are popularly called as pseudo generics. They themselves enter into the market with the generics and thereby prevent others from entering into the market, competing in that particular field also. Similarly, they have the defensive business strategy. Like they have the patent, they go in for licensing, they go out and then grant a license, and the other pharmaceutical company would rely upon the innovations made by this particular company and they would get license. Similarly, they also go in for cross-licensing. Licensing and cross-licensing is one of the business strategies of the pharmaceutical companies. They also have, as you know, outside the purview of this patent system, they go in for differential price mechanisms. To reduce the effect of the monopoly by the other organizations, the next strategy that they adopt is called as collaborative research. Well, these are the figures that you find from the field. As to the question of medicines, access to medicines, we notice that a third of world's population does not have regular access to essential medicines. And this ratio reaches levels of half the population in certain developing countries. The financial burden of expenditure in medicines in most of the developing countries is borne by individuals and not by the health insurers, either private or public, as it happens in the developed countries. There are various factors affecting access to medicine. The high-level committee has listed some of them, like unreliable medicine supply system within the territory of the developing countries, poor quality of medicines most of the time, going to the doctors, irrational prescription dispensing and use, unaffordable drug pricing, which is one of the important key factor, unfair health financing mechanisms, inadequate funding for research in neglected diseases, which has been bothering us for quite some time, a stringent product patent regime. These are all the reasons, right, for adverse effect on access to the medicines. What are the problems that we find in the R&D model of the pharmaceutical products? There is no clarity. There is lack of transparency of the R&D cost that's involved in developing a particular molecule. One particular set comes and says it would cost around $2.5 billion, whereas assessment by objective assessors has indicated that it would not be more than $43.4 million, or sometimes $55 million. So there is no transparency in the R&D cost. And similarly, this model here, resulting in high prices, have restricted access also. For example, there are around 71 anti-cancer medicines which were approved by US FDA, which cost more than $100,000 per treatment. Plus also, in R&D, there is total fragmentation and lack of coordination, each working in silos, as a consequence of which there is no overall comprehensive R&D development happening. Lot of waste and overlap. What is required here is a new R&D model based on health rather than commercial interest, generally supported on patents and other intellectual property rights, perhaps going to be designed and implemented under the auspices of the WHO, right, based on Article 19 of the WHO Constitution. Let me just quickly have a look at what happened during the COVID-19 crisis. The reason, friends, is we understand that major crises like that, they bring about challenges, but they also bring about opportunities and lessons. Perhaps when I say opportunities, this online debate or discussion is one of the new normal that emerged during the COVID period. World was devastated with millions of cases of COVID-19 and death of millions of people. But pharma companies' response was very fast. Previously, vaccine development used to take 7 to 13 years of R&D and $1.8 billion of clinical trials. Recall how the 9-year-old Joseph was given Louis Pasteur's developed vaccine on 6th of July 1885, the first vaccine to be given. Whereas during pandemic, it was only 10 months of R&D and tens of thousands of clinical trials. Just 10 months of R&D, no 6-7 years or 13 years. However, we noticed during that period what we call as the vaccine nationalism. Developing countries were affected with non-availability of vaccine on priority basis. For example, US entered into 6 agreements for more than 1 billion doses for just 325 million population, while UK, EU and Canada entered into 7 agreements for doses of vaccine to cover more than their population. Just go to Australia. It even stopped export to US also, saying that until our population is immunized, we are not going to export it to any other country. Well, AstraZeneca said, we will first provide 30 million doses to UK because UK funded us $79 billion. Indian Serum Institute also did not fall back. The director said that first Indian nationals to be immunized before sale outside, and several such instances happened during that period. What am I trying to tell here? We found purchase of individual vaccines was left to the market of supply and demand. Whereas concept of public goods advocated at the World Health Assembly seemed to have been sidelined. The disparity in administration of vaccine doses was apparent in the fact that, just see, North and South America administered around 127 vaccines per 100 people. 127 vaccines per 100 people. Europe administered around 199 per 100 people, whereas those numbers decreased when it came to Africa. It was 11 per 100. 11 per 100, the doses that were given. However, at a later stage, you find efforts at multinational level, WHO initiatives like the Gavi, COVAX AMC, they took initiative to produce a supply of vaccines for low-income countries and low and middle-income countries. Well, with all that, the question is, how can a balance be struck between the patent monopoly and access to medicine? There are developments at WTO that try to bring in flexibilities in the IPR regime in the interest of public health, such as was mentioned a few minutes back, the Doha Declaration itself is a very, 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 very healthy development. Followed by that, the August 30th decision. And then followed by that, the amendment to the TRIPS agreement. These are all the one which provided flexibilities in the IPR system, which would be favorable to the access to medicines. Within the framework of patent system, there are built-in flexibilities that favor public health. Let me draw your attention to some of them, which were referred to incidentally by the chairperson now. First and foremost, the patent eligible subject matter. See, what is included and what is excluded, though indicated in Article 27, 2 and 3 of the Agreement on TRIPS. Many countries have their own exclusions based on the policy requirements. For example, most of the countries have excluded second use of the known substance. And the classic case in India is Section 3D and 3D-like provisions in other developing countries. We know how the Supreme Court of India acknowledged the validity of Section 3D. 3D that prevents evergreening of patents but encourages incremental innovation by stating that any new form of known substance which does not result in enhancement of efficacy is not patentable. Right? Supreme Court upheld the rejection of patent for beta crystalline form of imatinib mesylate when imatinib mesylate was known and imatinib was already under the patent system. It said that beta crystalline form of imatinib mesylate does not satisfy the expected therapeutic efficacy standards. In the absence of therapeutic efficacy, it would not qualify Section 3D and is hit by Section 3D. That's one of the very, very interesting provisions and important provisions that you find, which limits the grant of patent to a pharmaceutical substance. Similarly, we have excluded the medical method patents as well. No surgical prophylactic method on any medical method can be granted patent protection. We have also excluded it on the basis of the traditional knowledge. We know how after TKDL database was provided to US and European Patent Office, several patent applications filed before those patent offices were either withdrawn or were rejected on the ground that this is a part of traditional knowledge found in the traditional knowledge database. The second flexibility that you find, friends, is the compulsory licensing, to which again the attention was drawn. Article 31 of the TRIPS provides in detail and the circumstances under which it can be authorized for use by others. Followed by this was the flexibility that was provided in the Doha Declaration, decision of August 30th. And in India, we have provisions from 83 to 92A of the Patent Act 1970, which elaborately provide for the compulsory licensing. I'll not be getting into all those details of these provisions. However, we know India granted one CL against Bayer in favor of NATCO when all three conditions were considered as satisfied. Reasonable requirement condition, affordable price requirement, and working of the patent requirement in India. Those were considered to be satisfied, and then based on that, the reasonable royalty was also fixed, though enhanced by IPAB at a later stage, and that is the only attempt made in India for grant of CL, although other two were refused by the Controller General of Patents. In fact, there have been 108 attempts to issue compulsory licensing for 40 pharmaceuticals in 27 countries since 1995. But as was pointed out, like very clearly by the chairperson, such attempts have met always with retaliatory measures from the developed countries like Thailand, Indonesia, and Malaysia. All these CL efforts were met with US pressure, and other countries also met with retaliatory measures. It went to such an extent that sometimes use of these flexibilities, right, affected availability of the other medicines also. Forget about obtaining that particular medicine at a cheaper rate by granting compulsory licensing. The best example that could be taken here is Abbott. Abbott withdrew its medicines from Thailand as a retaliation to the compulsory licensing being granted. So it was affecting the availability as such. The next flexibility that you find here is the government use. And in India, we have provisions like Section 47, 99 to 104, which provide for the government use that is invoked in other cases. Very interesting case that happened was Malaysia. Malaysia, it allowed the import of generic dedanosine, zidovudine, lamivudine, and then zidovudine combination from India to be supplied to the public hospitals. And for that, it invoked the government use provisions in its patent law. Another very important limitation on the rights of the patentee, preventing him from that particular monopoly, is the very, very popular Bolar exception. When a patent is about to expire and the generic manufacturer has to enter into the market, before which the bioequivalence and bioavailability tests are to be conducted, used for that particular purpose, so that that information will be provided to the drugs authorities for the purpose of getting market approval. Used for such purposes can also be an exemption or a limitation on the rights of the patentee. And this is what happened in the Bolar versus Roche case before the Court of Appeals for the Federal Circuit in US, and it has come to be called popularly as Bolar exception, which we have in our patent system, in Indian patent system as well. And there is another limitation in the form of the parallel imports, what we call as the exhaustion of the patent rights, depending on whether a country is following international patent exhaustion, national patent exhaustion, or regional patent exhaustion. When the patent exhaustion happens, then the drugs manufactured can be imported into a particular country and could be sold at a price at which they would have purchased could be a lesser price. And this is possible under circumstances. For example, differences in the patent duration in different countries, differences in the prices attributable to national price regulations, differentiation in the pricing strategy. Sometimes discounted prices may also be there in certain jurisdictions. Differences in inflation or exchange rates. So any one of these might prompt import from the other jurisdiction, which would be permitted within the patent system itself, would not amount to the infringement of the patents. And there's also flexibility in the form of test data exclusivity or data exclusivity, which is not mandatory to be provided by the member countries. They may or they may not provide. And a member country can avoid TRIPS plus provisions and policies. For example, extension of the patent term. You need not provide for extension of patent term as provided in US. India doesn't provide for patent term. Second use patents. Some border measures. And similarly, you can use the competition law to address the misuse of patents. Well, friends, export of the medicines to the needy country, which was not possible previously, has been made possible after the decision of the TRIPS Council, following the Doha Declaration. And we have incorporated that Doha provision in the form of 92A of the Patent Act. Well, these are all the flexibilities that are available within the patent system itself, so that you either restrict the grant of patent and patent monopoly for pharmaceutical companies, limitations there, or create exceptions wherein the public interest could be effectively served so that access to medicine is ensured. Outside the patent system, friends, public health issues could be addressed through pricing mechanisms, universal healthcare, competition law, and others. Just to throw little pitch on the pricing policy. There are different pricing policies adopted by different countries. There is something called as free pricing for patented drugs. Free pricing for patented drugs with very, very minimum limitations is what you find in USA, Malaysia, India, Singapore, China, and Germany. There's something called as value-based pricing for the patented drugs found in Canada and Australia. And the popular one, reference pricing, whether internal or international, for patented drugs provided in Canada for the breakthrough technology, South Korea, Spain, Italy, Netherlands, Poland, Hungary, Germany, and others. There's a direct price control. Some countries they go for direct price control even for the patented drugs, like Mexico, Austria, Finland, France, Greece, Ireland, Italy, Spain, Netherlands, Portugal, Sweden, Slovakia, and others. What is important, friends, is when you're looking at the healthcare, when you're looking at the health of an individual, access to medicine, etc., it is not just the patent system which has come in the way of access to medicines. There are many other factors which have been contributing here, which also can be addressed outside the patent system. For example, the universal healthcare system, which provides for the insurance systems to meet the needs of the healthcare financial demands. Well, friends, these are some of the rambling thoughts which I thought I would share today. We have experts in this particular field speaking today, Srinivasulu and Trisudha and others, who I'm sure would be addressing specific concrete issues that are bothering us, would be providing solutions for those issues, and we hope that access to medicine would be ensured to every individual on this planet, and a harmony between intellectual property rights and public health is maintained. With these few words, I thank you very much. My sincere thanks to one and all, especially Professor Benjamin and Mr. Hashmi for involving me in this particular process. Thank you very much. Namaste.
Thank you, sir. Thank you so much for such robust insights, comprehensively and comparatively from the different parts of the world. Now, it is our honor to invite Professor G.V. Reddy to deliver his address. Before sir starts his address, we would like to introduce sir to our esteemed audience. Ms. Sarah, please introduce sir.
It is my privilege to introduce our guest of honor, Professor Dr. G.B. Reddy, the Honorable Vice Chancellor of the National University of Advanced Legal Studies, Kochi, a position he assumed recently, marking a new chapter of visionary leadership at one of India's premier law universities. Before joining the National University of Advanced Legal Studies, Professor Reddy served as a senior professor of law at the University College of Law, Osmania University, where he also held several key positions, including IPR Chair Professor under the Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, and Director of the Professor G. Ram Reddy Center for Distance Education. His administrative acumen and dedication to academic excellence have left an indelible mark on Osmania University. A scholar of rare distinction, Professor Reddy earned gold medals in both LLB and LLM and was awarded a PhD in law in 1999 for his pioneer research on judicial activism and constitutional jurisprudence. His work continues to influence debates on constitutional governance and the evolving role of judiciary in India. He is also a prolific author with more than 17 influential books to his credit. His widely read works include Women and Law, Law of Consumer Protection in India, Intellectual Property Rights and the Law, Judicial Activism in India, Copyright Law in India, and Consumer Protection Act, a commentary. He has also edited volumes like Recent Trends in Corporate Laws, Bharata Rajangam, Indian Constitution in Telugu, and Intellectual Property Rights in Knowledge Era, Changing Contours. These works stand as testimony to his scholarship, policy insights, and dedication to advancing legal understanding in India. Today, we are truly honored to welcome an academic leader, prolific researcher, and visionary administrator whose contributions to legal education, research, and institution building are widely respected across India. Please join me in extending a warm welcome to Professor Dr. G.B. Reddy, our guest of honor. Thank you.
Thank you very much, Ms. Sarah. The distinguished juries, academicians, and other participants who are present online. The Chief Patron, Professor Dr. Loknath, the Honorable Vice Chancellor, University of Mysore, Srimati M.K. Savita, the Registrar of University of Mysore, and our guide and patron, Professor T. Ramakrishna Garu, the chief guest of today's webinar, Professor N.S. Srinivaslu, Professor Sanjit Kumar Chakrabarti, Professor P. Sri Sudha, Dr. Parimala Das Gupta, and of course, the organizing secretary and our good friend, the Dean, Faculty of Law, Mysore University, Professor M.S. Benjamin, and the young and dynamic coordinator, Mr. Syed Kudrat Hashimi, and other delegates and participants. I'm extremely happy to be part of this international webinar. And it was really a pleasure to listen to Professor Ramakrishna for his scholarly exposition of the topic on intellectual property rights in relation to public health in developing countries. And probably you are aware that we grew as teachers of intellectual property by observing such stalwarts like Professor Ramakrishna and a few from Kerala as well. As far as the present topic is concerned, I think the organizers have chosen a very timely topic of contemporary relevance, and especially with reference to developing countries, including India. Well, delegates, you know very well that intellectual property rights importance probably cannot be undermined or need not be re-emphasized at this stage, because we are talking about the knowledge economy, the knowledge century of knowledge revolution. Then we are talking about the knowledge industries, so on and so forth. And in this process, intellectual property is a means and a tool to create wealth, and it created probably some of the wealthiest men in the world, including Bill Gates and many more. But at the same time, by their very nature, the intellectual property rights, which are the result of creativity and innovation, also create monopoly rights, thereby creating a conflict between equity and innovation. Many of times, probably, this is what is witnessed all over the world. I'm reminded of the vision statement of the National IP Policy 2016, which says that we are talking about an India where creativity and innovation are stimulated by intellectual property for the benefit of all. I'm more concerned about this, for the benefit of all. An India where intellectual property promotes advancements in science and technology, arts and culture, traditional knowledge, biodiversity resources, so on and so forth. And where the knowledge owned is transformed into knowledge shared. Highly, utopian and idealistic and much needed. But at the same time, when it comes to the public health, right to health, in terms of access to medicines, or access to affordable medicines, or Medicare, or the other medical services, including the diagnostic and other services, I think most of us are failing. And probably, I think majority of Indians can't afford even today to get access to, in fact, the medicines and medical facilities at affordable price. So people have to rush to Apollo Hospital or VCare or Medicare or whatever it is. This is one important aspect. At the same time, we cannot ignore the most important aspect of life, that is health. Whether it is the health of a national of a developing country or the least developed country, or even the, in fact, developed country. You must have read the statement of J.D. Vance, the Vice President of USA. If something terrible happens, I'm ready to step in. That is to become the president, because Vice President has that, in fact, flexibility under the US Constitution. So something terrible might happen even from the angle of the health. And if health is lost, everything is lost. And it is very well established jurisprudence that right to live includes right to live with basic human dignity and without health, there can never be a basic human dignity. This is one important aspect. Well, friends, as far as public health is concerned, there are two important aspects here. One is health, the other one is the public health. There may be a fine difference between these two. When we are talking about public health, we are talking about a general access to medicines, vaccines, diagnostics, and the other related processes, facilities. But when it comes to right to health, it may be used even in the context of an individual. Both of them are dependent on each other. And as pointed out by the illustrious speaker ahead of me, the right to health can be traced to any number of international conventions, whether it is a Universal Declaration of Human Rights or a Covenant on Civil and Political Rights or Social, Economic and Cultural Rights, Sustainable Development Goals. The list is, in fact, very lengthy. And in India, and so in other developing countries, now right to health has been recognized as one of the, in fact, integrated components of right to live with basic human dignity. Under Article 21 of the Indian Constitution, there are any number of judgments, a plethora of judgments could be referred to with regard to right to health. And then what exactly is the issue now? The issue is the tension between innovation, invention, patenting, and other kinds of intellectual property rights on one hand, accessibility to medicines, etc. on the other hand. This is the tension. This is the present issue. So while international trade policies were formulated through WTO, through the TRIPS agreement, whether the public health concerns were taken into consideration, answer was yes, certainly, at least on the paper. If you look into the prefatory statements of the TRIPS agreement, you will find that public health has always been considered of primary importance. And at the same time, in order to have probably harmonization, maybe in order to enable the developed countries to have some kind of, in fact, hegemony, at least initially in the beginning of TRIPS agreements working, they mentioned that no question of confining the grant of patents only to process in certain cases. You have to grant both product and process patents in all fields of technology. I'm just drawing the attention of the delegates to Article 27, patentable subject matter. Exceptions could be found subsequently in the other following articles and provisions. But the member countries ultimately were sought to be brought onto the same platform with after 5 years, 10 years, 15 years, whatever. And then comes the Doha Declaration, you know very well. Doha Declaration is a turning point, and I don't see the direct connection between the Doha Declaration regarding the public health flexibility in TRIPS in 2001. But the fact remains that maybe the developed countries, including maybe US and China and other countries, they were really afraid of something like SARS, a disease which was spreading fast those days, and that must have hastened their in fact affirmation of the Doha Declaration, which gives flexibility to protect the public health by enabling the countries to go for even compulsory licenses among other measures. This is one important aspect. But in spite of the Doha Declaration, or even without Doha Declaration, we will find that many developing countries are modeled on the TRIPS agreement today because they have become TRIPS compliant. But as far as the enforcement is concerned, it is, in fact, slightly different from each country to the other country. This is one important aspect. Then let's look at the impact of IPRs on access to medicines. IPRs by very nature are limited monopoly rights. Therefore, when intellectual property rights create limited monopoly in favor of the creators or the owners or licensees, etc., the other stakeholders, certainly they will have monopoly in pricing also, drug pricing. So this is one important factor. So when we talk about the pricing, again, probably the governments of the day may not have unlimited right to control the prices. They may bring in some price control mechanism. I'll refer to that a little later. But the very basic principle of intellectual property protection is economic incentive, economic reward. So what they say is, when a life-saving molecule is invented and patented by spending few crores and millions or billions, certainly we have every right to recover the price, recover the cost, make a reasonable profit. Therefore, the governments of the day should not come in the way. They have their own justification to some extent, right? This is another important point. And now I think, right now I am in Kerala. Kerala is one state, I'm just deviating a little, where the testing is very prompt. Testing for any medical problem or disease, testing is very promptly done. People are not afraid. So almost every virus probably is found in Kerala. And the question is, nobody is safe everywhere. In fact, the human beings, animals, plants, during COVID, we have seen that neem trees died en masse. Hundreds, thousands, lakhs of neem trees died in some of the states. Whatever may be the case, now we have the threat of HIV. It has been there for the last 40, 50 years. Then AIDS, then tuberculosis, then malaria, so on and so forth. And when there are deadly diseases like this, life-threatening diseases, certainly we must have access to medicines to combat the impact of such diseases. For example, antiretroviral drugs. Look at these drugs used in treating the HIV and other patients, and look at their pricing before and after the generic production. At one point of time, the multinational corporations never allowed in fact, the generic manufacture or production of ARVs, antiretroviral drugs. If you read the writings of somebody like Carlos Correa, you will find that, in fact, many countries, especially developed nations, they were averse to the generic production of antiretroviral drugs, but that is essential. Without that, you can't treat them. Similarly, for example, the same multinational corporation, we have the concept of this compulsory license, the only compulsory license granted in India in respect of a patented drug. So that was Nexavar or Sorafenib, which was patented by Bayer company, which came up sometime in 2012, August or March or August, right? The point is very simple. Why compulsory license had to be granted? Because the price was around 2.84 lakhs per patient per month. Whereas the Natco Pharmaceuticals from Hyderabad, it was ready to sell it at a cost of 8,000 rupees per patient per month. Certainly, making it unaffordable, withholding the same from the general public, and compulsory license was granted. Everybody clapped. In India, it remains the only incident when compulsory license was granted. But when you look at the other countries, for example, Thailand between 2004 and 6 issued number of compulsory licenses for a number of patented drugs, including HIV, antiretrovirals, and cancer treatment drugs. Brazil, for example, with regard to HIV and AIDS epidemic, it issued a compulsory license for an ARV, this antiretroviral drug called Sustiva or Efavirenz for non-commercial use, which increased access to treatment. Zimbabwe, again a developing country, it declared a public health emergency relating to HIV and AIDS. And again, the government issued licenses allowing the production and importation of generic ARVs. Same thing was the case in Indonesia. So some of the developing countries have used these flexibilities either under the Doha Declaration or under the TRIPS agreement or under their national laws. This is another important aspect, please. And what is important is On one hand, you have the innovation which might, in a limited way, protect the rights of the stakeholders. But public need is larger as far as the base is concerned. So what could be done? For example, take the case of IPR incentivizes R&D. This is one important aspect because, without intellectual property rights protection, nobody goes for research and development. But the fact remains that most of the times this statement applies for profitable markets. What about the neglected diseases? For example, there are certain orphan drugs. This concept is used in USA. There is an act called the US Orphan Drug Act 1983, which says that if any disease, in fact, affects not more than 2 lakh people, 200,000 people, right? Then in such a case, any company which manufactures a drug, comes out with R&D, tries to invent something, come out with some solution, they can be incentivized. Exclusive marketing rights can be given, tax incentives can be given. This was, the process which was initiated in 1983. We need some such thing because there are a number of rare diseases which are affecting us. Similarly, WHO report says there is a market demand in developing countries which is very small and uncertain, which limits innovation. Therefore, we have to look for, the other solutions, need for alternative incentives. For example, PPP, public-private partnerships. Like during COVID, we have seen where that serum company permitted by the government of India to manufacture the anti-COVID drug, right, or vaccine. Then prize funds, open source models. And we have other, for example, DPCO. In India, very few people talk about this, except the pharmaceutical industry and maybe some of the NGOs. Nobody talks about drug price control order issued under, in fact, the Essential Services Maintenance Act, right? And when you look at this DPCO 2013, look at the list of the medicines, the price of which is controlled. Of course, patented medicines may not be covered by this, but still there is a method of, in fact, utilizing off-patent drugs for the purpose of controlling the, in fact, the prices. Or take the case of Jan Aushadhalayas. Prime Minister has come out with a scheme where generic drugs could be purchased, sold by the government licensed companies. So this is another method. Well, there are a number of case studies. Novartis, Professor Ramakrishna sir already explained. Section 3D was upheld because evergreening should not be permitted. And when Novartis wanted to evergreen the in fact, the cancer drug called imatinib or Gleevec, and it failed in Madras High Court. It failed in, in fact, Supreme Court. Supreme Court said it's a policy decision, but there is a hypocrisy on the part of the developed nations. On one hand, they say that no, you are scuttling innovation, research, so on and so forth. But on the other hand, they were trying to, in fact, go for evergreening, which is not in the interest of the public at large. South Africa, HIV and AIDS battle. If you look at the ARVs versus patent holders, you will find that as far as in early 2000, the South African country faced a severe HIV and AIDS crisis, and especially with patented antiretroviral drugs priced beyond reach. Only when the government invoked the TRIPS flexibilities and supported the generic imports, parallel imports, then only the prices came down by almost to 90%. East Africa's local antibiotic production also, same thing. In fact, the United Nations Commission on Trade and Development for IP flexibility, it supported some kind of regional investment in antibiotic manufacturing. Unfortunately, UN itself is getting weakened with bullying by somebody like Trump and others. But otherwise, that is a fantastic idea. Now the same thing should be done by BRICS, G20, so on and so forth. Brazil also did the same thing with regard to HIV drugs, and they issued compulsory licenses for the drug which I mentioned just now in 2007, and saving almost about 30 million US dollars annually and expanding the treatment coverage. Now, global responses are so many because WHO also talks about the global strategy on public health, innovation, and IPR. UNCTAD has a role in capacity building and technology transfer. This is really laudable, but I think it has got its own limitations. Doha Declaration empowers all the member countries to use the TRIPS flexibilities as far as public health is concerned. Most prominent among them is compulsory license, then parallel imports, so on and so forth. Now, for example, India is, again, I must quote Professor Ramakrishna sir. He mentioned about the health emergency, extreme urgency, not meeting the reasonable requirements of the public as a ground for declaring such emergencies, compulsory licenses, parallel imports. There are enough flexibilities even under the Patents Act of 1970 to protect public health. The only thing is, maybe, since we are living in a globalized world, it will be very difficult for us to live in silos. Ultimately, we have to, in fact, interact with the other nations. In the process, maybe the only compulsory license remains 2012 license and no more. Same thing may happen, but there are other policy recommendations. We can strengthen the local R&D. We can strengthen the, in fact, one of the methods is to strengthen the Indian medicinal system, regional medicinal systems, which are specific to the regions. TKDL, it is used only for defensive purposes. Maybe, something else, a new model may be brought out. Traditional knowledge, after WIPO has, in fact, permitted or signed this particular convention recently, traditional knowledge also could be positively exploited. Then TRIPS flexibilities could be exploited. Regional cooperation can be, in fact, improved further. There can be patent sharing. There can be patent pools or patent thickets. There are a number of ways and means. Now, what is the way forward? On one hand, we have to balance the innovation with equity. This is important. Equity as far as access to medicines, access to, medical services like diagnostic, surgical, prophylactic, therapeutic, so on and so forth are concerned. Then the ever-going question of the battle between patents and patients. So whether patents should win over always, patients should be left in the lurch. That may not be the case. A balance can always be made. That is another important aspect. Then AI can be used, big data can be used, genomics can be used in reshaping the IP and public health, and sustainable financing models can be used. And for example, now with the ongoing tariff impositions by United States, you must have seen that pharmaceuticals are left untouched. So that draws our attention to a fact, that even US is not prepared, even though they are so unreasonable, but they are not prepared to touch one important area from their own selfish point of view, not from our selfish point of view, as far as international trade is concerned. Now, to conclude, I will say only this much. IPR can be a human right, may not be a fundamental right, and it must serve the human rights and health equity, both of them, and therefore they are not one against the other. They must go side by side. That should be the approach of the stakeholders, and all the developing countries need some kind of legal, financial, and technical support and cooperation among themselves. So what is required today is collaboration, reform, and innovation, but with a human face. This is very important. So I take this opportunity to thank the organizers for giving me this wonderful opportunity and to share some of my views. And I thank all the distinguished speakers and delegates for a very patient hearing. Thank you very much. Jai Hind. Namaskar.
Thank you, sir. Thank you so much for your incisive remarks. We now have the privilege of hearing from our keynote speaker, Professor Srinivas Loyanes. Before we start with sir, I would like to request Ms. Sarah Benjamin to introduce sir. Then we will have one.
It is a matter of great honor and privilege to welcome a truly distinguished academician and legal scholar to today's session, Professor Dr. Srinivasulu NS. Currently serving as Professor of Law at the National University of Juridical Sciences, Kolkata. Professor Srinivasulu is a widely respected figure in both national and international academic circles. He is a distinguished member of the International Council of Jurists, London, and a scientific member of the Canadian Institute for International Law, Ontario, Canada. He is also affiliated with the World Commission for Human Rights, London, reflecting his global commitment to advancing the rule of law and human rights. Beyond academia, Professor Srinivasulu has played a pivotal role in shaping public policy. He has worked with various ministries under the Government of India, including the Ministry of Justice, Ministry of Commerce, Ministry of Human Resource Development, and Ministry of Transport, as well as with the University Grants Commission. He has also offered policy advice to several state governments, including Karnataka, West Bengal, Assam, and Goa, especially on matters of legal education and law reform. Professor Srinivasulu's blend of deep academic scholarship and practical policy engagement makes him a rare and valuable resource in the field of legal education. His insights are bound to enrich our understanding and inspire meaningful dialogue among us. Please join me in extending a very warm welcome to Professor Dr. Srinivasulu NS.
Good afternoon.
Good afternoon, sir.
It was indeed a pleasure to hear Professor Ramakrishna and Professor G.B. Reddy, the two senior scholars of intellectual property law. And also, I should thank and convey my best wishes to Department of Law, University of Mysore, for hosting this webinar and bringing galaxy of stars in the field of intellectual property law together on one platform. Indeed, my congratulations also due to Law Department, Mysore University, because in the past 1 year or so, they have hosted more than 15 international conferences and webinars by inviting speakers, scholars from not only India, but a number of other countries as well, facilitating a platform for dissemination of knowledge, discourse, debate, and discussion. It is indeed commendable as well because without charging any registration fee or whatsoever, Law Department, Mysore University is allowing hundreds of participants to make use of their regular conferences and webinars where a number of outstanding scholars are debating and giving their views and perspectives. So in this regard, the leader of the Mysore University Law Department, who is also my friend and my senior, Professor Suresh Benjamin, the Dean of University of Mysore Law Department. A big congratulations would go to him because he has been putting in tremendous efforts along with his young colleagues, especially Kudrat, Hashim, and Sarah, in making these programs a reality. Having said that, let me make it very clear that my speech today will be a rhetoric. It will be a rhetoric on the existing legal framework on intellectual property law when it comes to ensuring public health. My speech would be a satire on the way that we perceive intellectual property law and trying to mold intellectual property law's legal landscape to touch human rights canopy. And you can also count it to be a dissent when it comes to interpretation of intellectual property law, going by its philosophy and its objectivity, especially when it comes to public health. We have been taught, we have been discussing, we have been debating, and we have been made to understand in the legal circles that exceptions cannot eat away the general provision. The rule of law is general provision. The rule of law is set by the general provisions of law, and in rarest of the rare circumstances, we give way to exceptions or exemptions. When it comes to intellectual property law, private monopoly is the general rule. Patent monopoly is the general rule. Patent monopoly on pharmaceuticals is the general rule. And compulsory licensing, government acquisition, suspending the monopoly in case of public need, emergency, exigency, pandemics, majorly to cater to the public health needs or whatever, is an exception. So exceptions cannot eat away the general rule. That's what we have been taught. We have been understanding, and we have been preaching all along. When that is the case, why should we depend upon an exception? Because it's an exception, it's not a general rule. You cannot literally try to ensure public health by banking on exception. Because first of all, you are depending upon something which is a very weak platform, which is a very weak legal norm, and it is again going, it is also going against some established principle of law, that is, general rule will prevail, exceptions are only in the rarest of the rare circumstances. Number one. Having said this, because I mentioned in the beginning itself that my speech is going to be rhetorical, it is going to be satire. Having said this, let me also tell you people that intellectual property law is a private monopoly, right? Public health is the job and mandate of the government. You give private monopoly to the private individuals or corporates. Sometimes even government can also obtain patent monopoly. But nevertheless, generally, you are going to give a patent on a particular pharmaceutical, medicine, capsule, etc., to private individuals. There is a provision for it. There is a law for it, and you have prescribed some criteria. Only after the fulfillment of that criteria, as per the law, only you are granting some XYZ, some monopoly, and that too to the private individuals or corporates. Having done that, you are going back, taking U-turn and asking them to cater to public needs or public health, which is your job. That is a fundamental job of the government. Why are you insisting on the private entities to cater to public health, public needs? Why would they do that? They are private individuals. They are private entities. They have invested money. They have spent their time. They are using their skill and expertise. They would like to enjoy the revenue. They would like to en masse. Why would they literally, honestly cater to what you are saying? That is making the drug available at a cheaper prices, allowing generic medicine, right? Transfer of technology, training the people in acquiring that special skill through letting the information knowledge flowing down from upside down, right? All these things are based upon that special skill, whatever they have acquired, special innovation, whatever they have come out with, and on which you have granted a patent. And that too after you are satisfied with whatever criteria that you only have, government only has prescribed. right? So the fundamental point is public health is the job and mandate of the government of India, whoever is sitting in whatever position for that matter. You take care of it. Why are you insisting on the private people? They will not do. No patent owner will ever allow, ever ready to give that patent invention to the people in general. No patent owner will be happy or facilitate compulsory licensing, government acquisition, or technology transfer whatsoever. Nobody in this world can do that. This is the reality. This is a common psychology. This is a normal thing that every one of us know it. When that is the scenario, when that is the case, why generally we are going and beating around the bush? We are simply wasting our time, right? And trying to say that this is going to happen, that is going to happen, and all that. With all due respect to what our legal scholars think, my own earlier two speakers categorically mentioned also that more than 100 times governments have tried to get compulsory licenses or government acquisitions and all in the past 30 years. Hardly 3 or 4 could succeed. In the 78 years of independence in this country, right, only one compulsory license was granted in 2012 in the case of NATCO. We have Patent Act since 1969, right? So only once you have granted compulsory license. So practically going, if we are very honest, we need to understand that trying to push in public health into the private canopy or private laws canopy, commercial laws canopy, or intellectual property laws canopy, and mandating, asking, requesting, pleading, appealing these patent owners to allow the generic medicine industry to follow their innovative methods, asking them to allow compulsory license and all that. This is a myth. This is completely unreal. This is not going to happen. Rather, you have to figure out some other mean and mechanism by virtue of which you can go about catering to public health or such other things. How come private individual like you and me, how come you cannot mandate me to supply medicine and drugs to somebody who is sitting next to me? That's your job. That is the reason why you have been voted into power. You are the government. You are supposed to do that. Constitution has mandated you, government, not the private individuals. And intellectual property laws have been enacted by the parliament as per the powers given to parliament by the constitution. And the philosophy objective of the law is that you respect somebody who has done some work, some innovative work, which has fulfilled the criteria prescribed by the government. And there are exceptions, but those exceptions are exceptions only. Those exceptions cannot eat away the general provision. And that too, when it comes to public health, it is not the health of one individual or few individuals or group of individuals. The entire public health of the India means 150 crores of people. Public health of the entire world means 750 crores of people. One patent owner and 750 crores of people. One patent owner and 150 crores of people. How it is going to happen? Practically, literally, it is not possible. That's the reason why we have not come across number of compulsory licenses, not only in India, even across the globe also. Whatever way you try, in whatever way you try to convince, saying that ethics, moral, society, culture, all that, no investor will be in a position to listen to that, right? Anybody who has invested money, anybody who has spent 2 or 3 decades in a laboratory to come out with that particular medicine, pharmaceutical capsule, or whatever, will never be in a position to allow it. And that too, it will not be fair on our part also to expect that, because they deserve private monopoly, and whatever criteria that you fixed, they are fulfilled. And after 20 years, 10 years, whenever it is going to come, become part of the public domain, that too also they have accepted, right? They contributed to the existing domain knowledge, number one. They fulfilled your criteria. Number two, after 20 years of monopoly, it is going to become part of your public domain. Yeah, all the 3 criteria, whatever you prescribe, they have fulfilled. That's the reason why they are reaping the revenues, benefits whatsoever, right? Then, on a rarest, in the rarest of the rare cases, you can but there is no fixed mandate for it. How would you define? How would you define the rest of the rate case? How would you establish that the criteria for obtaining compulsory license or government acquisition has established, except in the cases like COVID scenario, pandemics and all that. Even during that time also, Government of India did not ask any private pharmaceutical company or any private owner of a patented medicine for a compulsory license or government acquisition. Very intelligent way, Government of India deployed Bharat Biotech Hyderabad and Serum Institute of Pune to produce Covishield and Covaxin. They only poured in money, they only invested, and no patent was granted. So that's the way out. If you want to take care of public health, you invest money, right? Or it could be in the public sectors like government universities or Government of India, Ministry of Science and Technology funded CSIR labs, we call it as Council for Scientific and Industrial Research, which is under the Government of India, is running more than 40 laboratories, research institutes across the country. You pour in money there and let them come out with vaccines, medicine, pharmaceutical, whatever, which you supply free of cost or at cheaper prices. Or allow the same innovations that the Government of India has produced to be available for generic production as well. Right. So that is the practical way out, and you have been success. You yourself has set a precedent by producing that Covishield or Covaxin during pandemic. That is how you can take care of the public health, right? In the past 75 years, as I mentioned, only one compulsory license that you could grant. That too, that medicine has become now more or less obsolete, and it is not catering to it is not really catering to the public health. But see, the Covishield Covaxin model, that is, Government of India itself invested money, and they only got that invention to be in their control without giving any private monopoly to whatever. And that has catered to not only 150 crores of the people, and you supplied, because free of cost you supplied that vaccine in more than 40-50 countries, including African countries. So that's a well-established model to take care of your public health by suspending patent monopoly, right? After you granted patent, how come you ask it to be given back? That would discourage research. That would discourage further innovation. That would discourage investment. Remember, intellectual property law is always trade connected. It is economics connected. It is not society connected. Right? It is not this law and society interaction by virtue of which you have brought intellectual property law. It is the interaction between industry and law. It is interaction between economics and law which has brought intellectual property law into picture. That's the reason why the famous intellectual property law convention, the Magna Carta of intellectual property law at international level, the TRIPS agreement, it is titled as trade-related aspects of intellectual property rights agreement, isn't it? So that's being the case, why I don't find any logic behind when we go about beating around the bush. Compulsory licensing, government acquisition, through these mechanisms you cannot ensure public health. Doha Declaration of 2001 made some attempt, and we all know what happened after of Doha Declaration, right? How many compulsory licenses you granted for public health after of Doha Declaration, which said that which in a way try to bring these exceptions in a more larger picture when you go for interpreting the TRIPS agreement and all that. But in reality, we all know the countries which are rich in technology, the countries which have invested money in that medicine, drug and all, they have never accepted to transfer the technology. They have never accepted compulsory licensing provision or government acquisition whatsoever. Only the countries like India, Africa, or say Malaysia, Thailand, Singapore, and Indonesia, such other countries, they may be thinking in terms of that. Even in these countries also, why talking about any other country? Let us talk about our own country. Why is that only one compulsory license you could grant? You are running the government. Government is in your hand. You can withdraw, no? Right? You can withdraw any patented monopoly. Why you did not do that? Why you only granted one compulsory license? During the COVID time also, why you invested money and got the Covishield, Covaxins both in your name? right? Because practically you know that you cannot mandate private people to cater to public health. You cannot ask, mandate, request, or appeal to the private private owners of the drugs or pharmaceuticals to cater to the public health needs, right? You may be having some laws at international level, and even within the Patent Act also there may be some provision you might have included, or you may say that TRIPS also, yeah, that's an exception. That's what I'm saying. It's an exception, right? And how you execute that exception is left to the member nations only, right? How exactly you go about implementing the exceptions, right? That is left to the member nations. International law has been framed in such a way that international law doesn't give you any direct guidance whatsoever. You interpreted that in exceptions in a very glorified way. Countries like America, they have not they have interpreted that exception in a very restricted way. They're also fine. You're also fine, because the so-called international has given you that flexibility. Then we cannot now blame on other countries who have gone for stricter interpretation of these exceptions, like USA or Europe. And you cannot say that countries like India only have gone about, are only taking care of social needs, public health, public interest, and all that, because you have gone about liberal, broader interpretation of that exception clause under the TRIPS agreement. So it is up to the member nations how they go about whether to give stricter interpretation or liberal interpretation when it comes to exceptions. But when you talk about the general provision, TRIPS agreement is very clear. There should be anything under the sun should be allowed for patenting. Anything under the sun should be allowed for IP monopoly. So in case of general provisions, TRIPS has made it very clear. Everybody will have to follow uniform, rational, and what you call homogeneous method of interpreting, executing, or implementing. But when it comes to exception, it is left to the member nations. See, it is also in a political way of making the legal structure at international level, right? Because general provisions are catering to economics, that they have taken care of. Exceptions are catering to sociology, so that they have not taken care of. That is left to the respective societies or nations. And that's why there is a lot of politics which has gone in the making of international law, not only concerning intellectual property law, but with respect to other international laws as well. So the point that I'm trying to say is, as in a satirical, rhetoric way, that catering to public health is first of all the mandate, the job of the government. It is not the mandate or job of the private entities or private individuals who have done some work in medicine field or pharmaceutical field. Number one. Number two, public health is an exception under the intellectual property law, but it is not the general rule under intellectual property law. Intellectual property law is meant for promoting research and development in science and technology. That is the general mandate. Exceptions cannot eat away the general mandates. And if you would like to go about ensuring public health in a better way, like you did in case of COVID, you invest money, you obtain patent for yourself. Government, nothing prevents government from obtaining patent for itself, because we have number of government universities and all that, right? Number of research labs, number of people working under your number of departments. Let them do. Why are you depending upon Bharat Biotech? Why are you depending upon Biocon, right? Why are you depending upon private players when you have your own people, right? Lakhs of professors are there coming from the field of medicine, pharmaceuticals, right? Lakhs of crores of money you are spending every year, the public money, taxpayers' money. Where it is going? Why your owned universities, why your owned laboratories, institutions are not producing the generic medicine vaccines whatsoever? Why are you begging before the private individuals, corporates, for asking their technology to be transferred, asking their patent on which you're asking for the licensing, government acquisition whatsoever? So this is nothing short of you failing, government of India. You failing. This is your failure, and that's why you are trying to push it on some private people and all that, private entities and all that, saying that there is a law, we are trying, but these people are not letting and all. So this is not a professional way of working it out. But that's why I said I not only I'm criticizing going in a rhetoric way or satiring the existing perspectives with regard to this. I have also mentioned the best model, the best method that we happen to pursue during COVID. Government itself funding and government itself having control and supplying. No questions. No, you need not beg before anybody for compulsory license or whatever, right? So that's the only way. That is the only way that you can ensure public health. You have to take complete control of those inventions or pharmaceuticals. Suspend IPRs like you did during that time, right? No IPRs whatsoever on anything which is connected with COVID pandemic, right? Not only that vaccine, any capsule, tablet, diagnostic method, treatment method, whatsoever, on all those things you suspended. And that is how you ensure public health during pandemic or exigency, emergency. Similarly, you empower your generic industry. You have your own labs, as I have mentioned. You empower your generic industry. They let them come out with their own invention. Those inventions could be better than the private people's inventions. For example, in 2013, Supreme Court of India, in the case of Novartis, made it very clear that Indian standards of assessing invention are very, very strict. Gleevec might have got, the applicant in that case, the company which has produced that medicine, Gleevec, with regard to them, Supreme Court said, you might have got patent whatsoever in other countries, but Indian standards of measuring patenting or the criteria, thresholds, qualification for patenting are very, very strict. You cannot just get away with, with a slightly improvised work and go away with the patent. It has to be completely new. So in such a strict way, you go about granting patents on medicine and pharmaceuticals. When you are such strict in allowing patent monopoly, why can't the patent owners be also strict while letting their hands off from their patented innovations? So what I'm trying to say is, practically it is not going to work out. We trying to bring in public health or public interest exceptions within the framework of IP because it doesn't suit IP's philosophy or objectivity. It doesn't suit the legal landscape that we have got in place. And also I said, IP is a private right and public health is a mandate on the government of India. You cannot, demand, expect private entities or private players to cater to your public health or such other public interest related needs for that matter. So we have to come out, government of India will have to come out. Maybe people like us will have to have consensus, and we have to recommend, and there has to one policy have to be evolved that rather than asking private people, we have to come out with, the government of India will have to come out with its own generic medicine, drug or capsule whatsoever, and we have a better established network, better established laboratories, universities across the country, right, which are functioning since 50s and 60s. Better experience, better equipment, better focus, better funding. Let these organizations come out with some patentable innovations, and through that only you can take care of the public health. It's not going to happen practically with you being asking, requesting for compulsory licensing or government acquisition whatsoever with private entities who have obtained patent monopoly. And the practical experience also shows it, not only in India, across the globe, these exceptions under the patent law or exceptions under the IP law for the public health cause have not yielded required or anticipated results, right? So this formula has, this strategy has never yielded any better results. So the possible model could be the model that we followed during COVID. So my intention is not to comment or criticize on people's perceptions or their opinions, but this I might have sounded very, very in a way a little harsh also, but this is the reality. That's why I mentioned in the beginning itself that my speech is going to be a rhetoric, a satire on what is popularly debated, discussed, understood with respect to this issue topic, and what actually is happening at the ground level, whether it is legally possible or not, practically possible or not. I thank my alma mater, Mysore University, for having me once again for this webinar. And I also thank all the participants, very huge number of participants, for giving me this patient listening. Thank you one and all.
Thank you so much, sir, for your comprehensive and enlightening keynote. Now, it is a privilege to invite Professor Sanjit Kumar Chakraborty to share his distinguished speak. So before we proceed with sir, I request Ms. Sarah Benjamin to introduce her, then we will hear from sir. Ms. Sarah, over to you.
It is my honor to introduce our distinguished speaker, Professor Dr. Sanjit Kumar Chakraborty, Professor of Law and Director of the Center for Law and Social Justice at the West Bengal National University of Juridical Sciences, Kolkata. Professor Chakraborty began his academic journey at the University of North Bengal, where he earned his BA Law and LLB and LLM, graduating with the University Medal in 2005. He then went on to earn his PhD in intellectual property law, focusing on the interface between plant intellectual property rights and human rights. With nearly 2 decades in academia, Professor Chakraborty has previously taught at institutions such as Kalinga Institute of Industrial Technology University, Bhubaneswar, before joining the National University of Juridical Sciences in 2012. He leads the Center for Law and Social Justice at the NUJS, where his work influences policy through legal research and public engagement. A prolific scholar, his research spans intellectual property law, traditional knowledge, disability rights, constitutional law, jurisprudence, energy law, and access to justice. His recent works include critical analysis of gender judicial treatment of women, data as a property concept, legal protection for the elderly, and environmental justice. Beyond scholarship, Professor Chakraborty actively mentors doctoral candidates and drives empirical research on social justice issues such as the protection of traditional medicinal knowledge and intangible cultural heritage. Today, we are privileged to have with us a scholar who seamlessly integrates academic rigor with social justice concerns and policy influence. Please join me in extending a warm welcome to Professor Dr. Sanjit Kumar Chakraborty, our keynote speaker for this event. Thank you.
Okay, thank you, Sarah, for your nice words. First and foremost, I want to thank Professor Dr. M.S. Benjamin, sir, the Dean, Faculty of Law, Chairman and Professor of Department of Studies in Law, University of Mysore, for extending that invitation. All the learned participants and all the dignitaries, whoever are present online. So it is my privilege actually. I heard Professor Srinivasulu sir, Reddy sir. I also tried to listen Professor Ramakrishna sir. So all of them, they tried to explain this particular topic or this particular theme from their own perspective. And my own senior colleague, who is my mentor too, Professor Srinivasulu sir. He also discussed this topic, and according to his language, it is a quite rhetoric and satire. Rather, rhetoric or satire, I labeled, his deliberation as a realist approach. Okay. But as Sarah was mentioning, that, I have a different aspect, and I try to look the things that how it can serve the social justice purpose. And similarly, or in the line of that, I framed my title actually, for my presentation or the explanation of that particular topic, that balancing IPR and public health in developing countries, a justice-oriented approach. I'm not going to adopt the realist approach. At the same time, I am also not going to this normative approach. Okay. Rather, I'm trying to mold this particular concept system. Obviously, it is not beyond the application of law. And what is the purpose of law? what is law actually, and what we want to achieve through law. If you ask me this question, I will simply answer in that manner that each and every political society, for each and every political society, the very basic objective is to achieve justice. And laws are nothing but the instrumentalities of justice. That is, through law, we will achieve justice. And that concept of justice, it is very much discussed by different philosophers. It has been documented in different documents, as well as through the preamble of the Indian Constitution. So the basic normative features or the hierarchy of the norms, we have our Constitution, and the preamble of the Constitution, it says that we will ensure the legal system, that is the constitutional mechanism, to achieve socio-economic and political justice. So this is a very national notion or the domestic notion of justice. And here I am trying to take or use the IPR which already gone global. Okay, we are already witnessing that the global IP system is much more a stronger one or the visible one in comparison to the national one, for whatever may be, whatever reason it may be. Now, if I look into the very concept of justice, justice, it can be defined from the different dimension, but justice, if I take a few versions, that justice as equality, justice as reward, and justice as welfare. Justice as equality. Rather, I must go for equality to equity, and justice as a reward, that if I am doing something, if I am creating something new, then I must be rewarded. This is also a core concept of justice. And justice means as welfare. That is doing something good for the people, that is the large number of people, and that concept of justice can be easily described as a social justice. One of the most prominent concept of justice, that has been theorized by, John Rawls, that is look into the very positive approach of the intellectual property law, that it intends to create some monopoly, it intends to give incentives, and one of the very basic argument is that without incentivization, people will not create, people will not innovate. Ultimately, the large number of people, they will not get the benefit of innovation. Now, keeping in mind, the concept of justice, what we have, maybe theoretically or from the purview of the Constitution, the entire structure of the intellectual property rights in the 21st century, I can describe it as a techno-economic paradigm. That is, intellectual property rights already entered into that techno-economic paradigm. That is, here technology and the economic utilization or the economic exploitation or the commercial exploitation of that technology becomes the primary focus. Now, in all the literatures, actually the topic is of such a nature that there is no dearth of literature on that particular topic. But if I look into the conceptual and analytical framework of the entire discussion of the intellectual property rights, it can be broadly, classified into three, or there are three aspects of conceptual and analytical framework. Number one, the natural rights or the moral rationale. Number two, the economic incentives rationales. And perhaps Srinivas Sulu sir pointed out or emphasized on these two particular points, that is the natural rights and the moral rationales. I am the inventor, I have invented, I have to be given the right, and the economic incentives out of that. But if we look into the another aspect of the intellectual property rights, that is intellectual property rights, it is a mechanism not only to give benefit to the inventor or give monopoly rights to the inventor. Rather, intellectual property rights, that particular system, it has a role in organizing science, technology, creativity, and giving access to the large number of population. So this analytical framework, even if we look into the writings of John Locke, that he categorically mentioned that government do not create property rights but are instituted to serve as their objective guardian. Uh, that discussion, if we can make that, yes, the property, who are creating the property? It is the individual like us. We are creating the property. Even Thomas Hobbes also, in his positive theory, he said that there is nothing natural about a rights if the protection of that rights depends upon the government mechanism. Now, when we argue that when I have created something new, naturally it belongs to me, according to Thomas Hobbes, you can't claim it as a natural right, because ultimately to enforce your right upon that particular property, you have to depend upon the government mechanism. And the law is that, or the composition is that government do not create the property, rather it is the individual who creates the property. Now, if we look into the political expediency argument of the intellectual property rights, it says that intellectual property rights is a system through which we can give some sort of market protection. And this market protection, it is given on the basis of the assumption. What is that assumption? Number one, that in absence of protecting novel ideas, inventor will keep their invention secret. It is in the interest of the society to induce inventor to disclose their invention and come out with that particular product in the market so that the general people can use it. There is also one assumption that intellectual property rights help to facilitate the worldwide sharing of ideas or the creative efforts. And it is also believed that the creators foster the knowledge, or it results to the knowledge spillover when there is some sort of intellectual property protection. So, these are the assumptions on the basis of which intellectual property rights have been argued or the protections have been sought. Now, if I, look into the law from this, ethical perspective, let us see that what are the ethical perspective. I agree with many of the speakers that exceptions or the ethical exceptions or the ethical norms can't override the positive law or the realist approach. But at the same times, I want to put this point in a very straightforward manner, that law is not only about what it is, rather law is also about what it ought to be. And if I agree and if I take this point for my argument, so I will say that intellectual property rights itself is a human right. If I go to Article 27 of the UDHR, there it is mentioned. And in Article 27, Clause 2, it is mentioned that intellectual property rights, it is a human right. It specifically says that everyone has the right to the protection of the moral and material interest resulting from any scientific, literary, or artistic production of which he is the author. Very good. What is Article 27(1)? Article 27(1) actually gives us the human right to claim that invention or the innovation which has been made by other people, and we have this right. Rather, we can participate as to the enjoyment of this particular innovation. So, that means the documents, that is the UDHR, it guarantees IPR as a human right, as well as using the creation as created by the others. It also confers a human right for that particular people. Now, it is rightly mentioned that as it has been rightly described, that is the Magna Carta. I also mentioned that already there is a globalization of IP because of its own nature. So under the WTO mechanism, the TRIPS agreement which we have, the TRIPS, one of the very basic or the very fundamental aspect of the TRIPS agreement is that it declares that intellectual property rights are the private rights. There is no doubt about it. But if you look into the, that in the era of globalization, that is the, trade liberalization, privatization, a question always comes that can the private property serve the public purpose? This is a question. Now, the socialistic concept which has been incorporated in the preamble of the Constitution, the Supreme Court itself in different case law says that we use, or the framers of the Constitution or the by way of amendment, the word has been used for limited meaning. Okay, but when there is an increased trend of acquiring property, that means if we look into the literature, for example, Engels, when he wrote the development of the family and the concept of ownership and property, even in his very small book, he tried to point out that it is the very basic tendency of the human beings to acquire more and more and to claim the property as of his or her personal one. Now, the WTO under the TRIPS mechanism, while describing these intellectual property rights as a private rights, it also says that there is some sort of policy perspective, and it gives some sort of flexibilities, so that the individual nation or the state, they can frame their policy and they can frame their laws according to their own socio-economic background. Obviously, the TRIPS mandated some sort of minimum prescription. Okay, that is the standard formula. Now, the question is actually for me is that how to extract the balance, between the TRIPS mandate and the welfare aspect as a concept of justice for the people, when more specifically the public health is concerned. Now, if I look into the TRIPS agreement, yes, I am not saying that, or rather my argument is not that, we have to rely or we must rely only upon the exception. But obviously, I must read the documents, that is the TRIPS as a document, as a whole. And if I read, TRIPS is not a straitjacket formula. It cannot be, interpreted in that manner. If I look into Article 7, if I look into Article 8, Article 30, Article 31, it incorporates flexibilities. Flexibilities, even, the transition, so far the pharmaceutical products are concerned, which has been extended till 2034, or the, least developed countries, they are graduating from their LDC status, whichever is earlier. If we look into Article 62, Clause 2, 66, Clause 2, that is the technology transfer, which says that the developing countries must promote transfer the technology to the least developed countries. Now, even the Doha Declaration, Srinivas sir also mentioned, while addressing that Doha Declaration on TRIPS and public health. And there it is specifically mentioned that TRIPS, quote unquote, does not and should not prevent members from taking measures to protect the public health. That means TRIPS is not a straitjacket formula. Flexibilities are there. For the least developed countries or the developing countries, there are some sort of flexibilities, and we can use those flexibilities in order to ensure public health, obviously from a broader purview of justice concept. Now, when I look into this intellectual property rights and the justice or human rights, I am very much influenced by the writings of Professor Sir Lawrence Helfer. Okay, he is one of the most contemporary author who is writing quite extensively in this area, that whether this intellectual property rights, which is very much private in nature, on the other hand, right to health, which is which comes within the broader purview of the human rights, which has its origin from the natural law theory, can they stay together or can they work together? So here I want to take three propositions, and I want to say that yes, they can work together. Rather, IP can be seen as a mechanism to achieve the human rights objectives like public health. Number one, my proposition is that intellectual property system serve people and not the other way around. Whatever may be, intellectual property protection, this protection is being given by whom? By the sovereign authority, that is the state. And as I already mentioned, that nothing is natural or nothing can be claimed as a natural right when the enforcement of that right depends upon the state system. So my first proposition is that intellectual property system, like any other legal system, must serve the people. Number one. Number two, intellectual property must remain a means to promote human welfare and not an obstacle to fulfillment of the fundamental rights. Okay, that means it should not create an obstacle. Rather, right to health, obviously it is a fundamental right. There is no doubt about that. And like any other legal provisions, these legal provisions also must promote the human welfare, not to create an obstacle. And the third proposition, which I want to propose, actually, I have taken this from the writings of Andres Eby and C. Giffen. In the year 2013, one article has been published in the Science and Technology Law Review. And the title of the article itself is, one proposition. What is that? Necessity is the mother, but protection may not be the father of invention. Incentivization cannot be the father. Rather, it is the necessity which is the mother of all innovation. So it may be, it may be the corona vaccine. It may be the, from magnifying glass to X-ray machine. All these things, it have been developed not only because there was some concept of incentivization. Actually, people innovate on the basis of their necessity. So in this article, both the authors, they actually, they have taken a very, very scientific approach. And they tried to show that, see, after the introduction of the intellectual property rights, as such, there is no tremendous development of the science and technology. Rather, science and technology, the development, all these things are taking place on the basis of the necessity, on the basis of the people's claim. Okay, incentivization rather, gives an opportunity to the corporate entity or the MNCs to, have some sort of strategic component, so that they can earn more from the market. Now, if I look into, some, obviously I have the broader perspective of the human rights concept or the justice concept. So my first criteria concern is that, public health should not be so costly that the majority of the people, they can't, avail it. It should not be like that. Now, IP results to some sort of scarcity. Rather, it creates some sort of monopoly, and obviously it is a scarcity. If you give the product patent, obviously the other one can't come with the same product. Okay, if you give the process patent, some other one can't use the same process. So it is nothing but a way to create some sort of, mechanism so that I can create an artificial scarcity in the market. Now, if I look into the CESCR General Comment number 14, that is, and Article 12, they are particularly mentioned that right to highest attainable standard of health, So there, it is quite specifically mentioned that even in case of intellectual property rights, there are many things, that is the international legal mechanism, there are many things which can be used in order to achieve the highest attainable standard of health, under Article 12. already, the compulsory licensing provision as NATCO, it is mentioned. I am not going to repeat. So if we look into the developing countries, including India, more specifically from the perspective of the COVID-19, and if we look into the provisions of the data exclusivity and the TRIPS plus pressures, we can see that the the pharmaceutical sectors, they are taking this particular this mechanism, that is the patent mechanism more specifically, in order to go for some sort of broader commercialization of their product. But as a nation, what is my intention? Now, what I want to achieve through this legal system, including the IP system, what I want to achieve. So there, when I look into the preamble of the Constitution, I look into the UDHR, I look into the very basic, the economic, social, and cultural rights, or the civil and political rights, or even the National Intellectual Property Rights Policy 2016. If I look into the policy, what the policy says? The policy says that we must have a stimulate, dynamic, vibrant, and balanced intellectual property rights system in India. Balanced intellectual property rights system in India. What is that balance? Intellectual property legislation itself are the nothing but the mechanism to balance two contradictory interests. For example, I am an inventor, I want to earn more, and there is a person who is the possible user of the invention, he wants to pay less. Now, intellectual property rights is a mechanism which intends to make a balance these two contradictory interests. And the first ever IP policy, yes, we have the intellectual property law maybe for long time, but the first IP policy which we adopted at the national level on 12th May 2016, it says that India must have a dynamic, vibrant, and balanced IP system. So it is not an IP mechanism which only look into the interest or some sort of make good or make profit out of the investment made by the investor. Rather, if I look into the policy, there is specifically mentioned that the mission of the policy is to focus on enhancing access to healthcare. What does it mean? What does it mean? That my IP policy, it will be a balanced IP policy, and that IP policy must enhance the access to healthcare. Now, if I look this particular issue from a broader perspective, as I started with the what I want to achieve through the legal justice system, what I want to achieve from my constitution, what I want to achieve from my legal system, including the IP legal system, then I think we have the rights way forward. There are something we can do. Number one, that there are certain areas which we must identify. Very recent, we have some issues are going on between USA and India. Now, what are the issues? If you look into the issues, then you can understand that we are not opening up the agricultural sector or the dairy sector, for the foreign investment or the opening up, so for the export, import, and all these things are concerned. So here, the very basic objective is that, even today, 63% of my total population are directly or indirectly depending upon the agricultural income. So how can I put this entire population for an unequal competition at the global scenario? So yes, I agree that exception does not constitute a general rule. Rather, we must follow the rule of law, that is the normative approach. But at the same time, I always think that law is there in order to serve certain particular purpose, in order to achieve something, and that goal is very much articulated through the preamble of the Constitution, that legal system, through legal system or through this constitutional mechanism, we want to achieve socio-economic and political justice. So from that particular perspective, my suggestion is that and there is a growing trend, because a few minutes back I mentioned that TRIPS provide some sort of common standard, or it is a minimum protection. And nothing of the TRIPS agreement prohibits or creates an obstacle for any state to go for the maximum protection. So now the developed countries are not happy with this minimum protection, and continuously they are accusing us that we are not respectful to the IP of others. And on that claim, they are entering into some sort of multilateral and the bilateral agreement. We must not commit the mistake again. If we look into the history of the TRIPS negotiation on behalf of India, actually we could not negotiate at that point of time, quite methodically, or rather, we are, somehow, if you allow me to quote Professor N.L. Mitra, one of the member, for the WTO negotiating team, that on my eyes, I saw that India is failing. And India is failing because what? Because we are not prepared, to review this particular agreement or that particular draft, and we could not negotiate them with, section article to article, or the provision wise negotiation could not take place. So this is number one. Number two is that, there is a modern, increasing trend, to coming with some sort of modification, alteration, or without making any substantial changes or the substantial modification. That is the people, the companies, they're trying to create some sort of patent thicket. So we must adopt some sort of, strict patentability criteria. And we must use the human rights jurisprudence to balance exclusively with access. Yes, there is nothing which can prevent us to take a very positive approach. But since my objective is to ensure justice, to provide healthcare for a large number of people, I would suggest that we must use the human rights jurisprudence to balance exclusively, to that access to healthcare. At the same time, I am I will reiterate this point, along with some few earlier speaker, that government must also spend for innovation. If we look into the graph, that R&D expenditure. Now R&D expenditures, it is very low. Even it is very low. If it is not even far behind from the budgetary provisions of the very small country like Finland. Okay, so the R&D investment by the government must be more. Here I will agree with Srinivasulu sir that there must be some sort of institutional investment, and we must increase, or we must develop the institutional capacity so that the R&D can take place on behalf of the government organization or on behalf of the government also, so that the government can distribute or the government can give access to that particular innovation for the general people. Monsanto is one of the agrobiotech company. One company's annual budget for R&D, it is far more than the Indian government allocation for R&D activities in agriculture and research. So, a nation's R&D investment, it is lower than a private company, investment. So that particular things must be taken into consideration. At the same time, COVID actually gave us a lesson, and it also created an opportunity that it gives us a reason to think upon, the promotional regional cooperation, that is promoting South-South collaboration, not rather than North-South, okay, or the global South and the global North. That debate will continue, okay, even in the writings of Professor B.S. Shimi, the third world perspective, if we say, then all this international development or the international organizations, they are actually there in order to serve the purpose of the global North people or the global North countries. Here we can look that South-South collaboration, more specifically in the area of pharmaceuticals manufacturing, and distribution. Now, I want to just conclude with the one observation made by James Hickman, Robert Nelson, and William Newcomb. They pointed out that whenever we are analyzing any legal system, whenever we are trying to understand law, the, I quote, fundamental normative question as to what defines a good life and what the ultimate ends of a rule of law system might be. That is the fundamental question. That what defines a good life? What is a good life? And ultimate, what is the ends of rule of law? Now, no one can deny that we are living in a country where rule of law prevails and not rule of man. And rule of law, if it is rule of law, then obviously by law we have to define that what is the meaning of the term good life, and law must ensure it. And law must ensure it. So if I think or if I keep this thing in my mind, then obviously it attracts me one writing by Professor Christopher May in the books that is the Global Political Economy of Intellectual Property Rights, the New Enclosure. That is the title of the book. In this book, the author wrote, I quote, property rights and intellectual property rights do not just emerge, but are constructed to serve particular interest. My argument is here that one of the interests must be to facilitate public health. I repeat, one of the interests must be to facilitate public health because according to Christopher May, intellectual property, they do not just emerge, but are constructed to serve particular interest. So one of the interests must be to facilitate public health in a country like us or in other developing countries. With this, I want to conclude here. Again, I want to thanks to the department, all the members of the organizing committee, and Professor Benjamin sir for giving me an opportunity. Obviously, though it is online, sometimes I feel a little bit, uncomfortable. Otherwise, we could have take some sort of question answer session or further discussion. Anyway, thank you very much, sir.
Thank you, sir. Thank you so much for your thought-provoking and critical perspective on social justice dimension from the lens of IPR, TRIPS, and constitutional law. Now we move to our last speakers for today's program, Professor Dr. Siri Sudha. Before we start with ma'am, I would like to request Ms. Sarah Benjamin to introduce ma'am, and we shall move ahead.
We are honored to host one of the leading legal academic, Professor Dr. P. Sri Sudha, Professor of Law and Dean at the SRM School of Law, Chennai, under the SRM Institute of Science and Technology. Professor Sri Sudha brings over 2 decades of academic excellence, leadership, and innovation to legal education. She holds both an LLD from the National Law School of India University, Bengaluru, and a PhD in law from the Andhra University. She has held key academic and administrative roles, and since mid 2024, she has served as the Dean of the School of Law at SRM Institute of Science and Technology, where she continues to enhance the school's academic standing and institutional growth. An accomplished scholar and educator, Professor Sri Sudha's teaching interests span core and emerging fields of law. Beyond classroom instruction, she plays an active role in shaping legal discourse on the future of legal education, including the integration of artificial intelligence and digital learning methodologies, a subject on which she has recently shared valuable perspectives. Through her dual roles as teacher and leader, she is committed to nurturing the next generation of legal professionals equipped for the challenges of globalization, technological disruption, and multidisciplinary legal practice. Under her deanship, SRM School of Law has undertaken several initiatives to foster academic rigor, industry collaboration, and international engagement. We are fortunate today to benefit from her insights at the intersection of law, education, and innovation. Please join me in extending a warm and enthusiastic welcome to Professor Dr. P. Sri Sudha. We eagerly look forward to her address and the knowledge she will share. Thank you.
Good evening, one and all. First of all, thank you so much for a positive introduction. Let me thank Professor Benjamin, Dean School of Law from Mysore University, for providing me with a wonderful opportunity to share certain important perspectives on this August gathering. Before that, it is my responsibility to pray my pranams to my mentor, guide, Professor Ramakrishna sir. During my LLD days, he used to guide me in various aspects of my postdoctoral research. Today, it is a great opportunity for me to share few important aspects pertaining to this vibrant topic, TRIPS, public health, and the recent developments. And after that, let me convey my pranams to Professor G.B. Reddy, Vice Chancellor, NULS, and my best wishes to my beloved colleague, Professor Srinivasulu from NUJS. And after that, Mr. Professor Sanjit from West Bengal National Law University. Very good evening to one and all. So we have started our discussion with regard to one of the most important topic, that is whether the TRIPS flexibilities are really helped India, or what are the challenges we are facing being a largely populated country. I can say I cannot present my perspectives in a rhetoric way, but a humanistic approach is my approach for the purpose of sharing certain important aspects on this day. So first of all, let me start my talk with a very, very recent judgment which was delivered by Kerala High Court with regard to compulsory license pertaining to one important drug popularly known as Recidipam. It is a 2025 judgment. So in this case, the price of this Recidipam ranges from 6 lakh rupee per month. Let me explain the facts, issues associated with this important case. In this case, one patient is suffering from a lifestyle disease popularly known as SMA, spinal muscular atrophy. So out of 7,000 people, one person will suffer with this disease. When the parents are not in a position to afford for the treatment of the patients, they have approached Kerala High Court for getting these medicines should be reimbursed from the side of state government. And the Kerala High Court has directed the government of India, that is central government, because according to constitutional framework, it is the responsibility from the side of central government to take care about the citizens of India, like the previous speakers, Sanjit and others. They are talking about Article 21 is the right to life enshrined under Indian Constitution. In this case also, Kerala High Court has directed the Union government to reimburse 50 lakh rupee for the purpose of treating the patient. But the Supreme Court of India, so they have stayed the direction which is coming out from the Kerala High Court. The reason behind maintenance of this silence from the Supreme Court of India is very, very important for our discussion. Like my good friend Srinivasulu sir has rightly stated, India is a market economy wherein public-private partnership is more popular when it comes to pharmaceutical or the drug manufacturing as well as treatment of the patients. So that is the reason why, what did they say is, imposing such kind of cost from the side of central government will lead to disastrous consequences, because the government cannot afford to pay that much money. So this is the verdict given by Supreme Court of India. And after that, one professor from UL University, being a amicus curiae, he has submitted his amicus curiae petition before Supreme Court of India by stating the fact in such a way that as India has emerged as the fourth global supreme power when it comes to its GDP percentage, it is the responsibility from the side of state to reimburse this 50 lakh rupee for the purpose of treating the patient. Still, the issue is pending before the Supreme Court of India. Like that, my dear friends, at the time of interpretation of the constitutional provisions, as well as the international agreement provisions like TRIPS and all, the human rights perspective is very, very important. But at the same time, being a sovereign state, state will have its own obligation for the purpose of supporting the public health issue. So every time it is not possible from the side of state to invest the money which is expected from the side of citizens. And after this, my dear friends, let me share one more important survey which is done by SRM School of Law in collaboration with School of Public Health at SRM IST with regard to accessibility as well as availability of cardiovascular disease related medicines. Dear friends, one way happily we can say that the lifespan of individual is enhanced because of our IPR only. But on the other side of the coin, after COVID, maybe a 40 years person and the middle-aged people starting from 40 to 50 are also subjected to this kind of CVD issues. According to World Health Organization, in the previous year, around 17% people were died at India because of these CVD diseases alone. So whenever we talk about this CVD, there are four broad categories of diseases are prevalent at Indian level. The first one is heart attack. Second one is heart failure. The third one is a heart stroke. And the fourth one is aortic heart disease, wherein a group of pulmonary disorders leads to causing this heart pain and ultimately the patient will die. So if we look at the reason behind these four kind of cardiovascular diseases, the first reason may be genetic reason, the second reason may be climate change, and the third important reason may be lifestyle. Why I am discussing about the survey which is done by us in this August gathering means whenever we talk about public health issues, during my grandfather's time, malaria, kind of malaria as well as yellow fever, kind of diseases is the biggest problem to governments. After that, HIV, but very recently, after pandemic, this CVD was also included by World Health Organization is one of the highest risk faced by developing countries, especially in India. The percentage of cases are in increase. And one more important thing, for the purpose of treating these CVD diseases, starting from diagnosis to treatment, the availability of branded drugs are more when we compare with generic drugs. So whenever we talk about generic drugs, the HIV drugs successfully we have invented, and certain antibiotics, and like Professor G.V. Reddy sir has rightly stated, in vitro drugs are a specific set of drugs successfully we have created generic versions. But when it comes to these heart-related diseases, still we are dependent on branded drugs only. So because of these branded drugs, so if the same drug is available, for example, we have compared what are the various countries who are manufacturing these generic versions. So at Indonesia, this medicine is available with 780 rupee, whereas in India, a blood thinner may cost with 4,200 rupee. So that is the reason why during our research, we have identified one important factor in such a way that if an individual is subjected to this CVD disease, so their entire family is surrounded with a vicious circle of academic liability, because at US, the government will fund for the purpose of their treatment. So their public health is very, very strong. But whereas in India, still our population are spending the money from their pocket. So that is the reason why it is very, very important. So from afternoon 2 o'clock onwards, continuously we have focused about branded versus generic drugs. But during our research, we have identified one more important aspect, that is with regard to the angiography. Also, for certain kind of cardiovascular diseases, the cost may go up to 40,000 rupee. With regard to cholesterol monitoring, also, so it is a continuous process. It costs around 15 to 20,000 rupee. And after that, we have identified one more segment of medicines for the purpose of treating the CVDs. They are blood thinning medicines. So once a person is subjected to this kind of heart-related diseases, for a continuous time of 10 to 15 years, he has to use the blood thinner. The price of the blood thinning medicine, each tablet costs from 40 to 50 rupee. And after that, certain patients are using some sort of inhibitors. Its cost ranges from 40 to 80 rupee. And after that, we have also examined the costs associated with medical procedures. If it is a angioplasty, on an average, if the angioplasty is conducted at government office, it costs around 2 lakh rupee. But whereas in private hospitals, it costs go up to 4 to 5 lakh rupee. And after this, we have also estimated post-surgery treatment medication cost also. It costs around 1.5 lakh to 2.5 lakh rupee. So friends, here what I intend to put forth before you, at the end of our research, what we have realized is after this LPC, we have signed on this TRIPS agreement and we have invited all the multinational companies. When this kind of public and private partnership kind of thing is there, the government is not contributing for many things. That is the reason why too much privatization is going on when it comes to this CVD. And with regard to the legal mandate also, World Health Organization has come out with an action plan. So according to World Health Organization's action plan, before 2025, around 80% people should get access to these CVD medicines. But during our research, we have identified at Chennai itself, only 25% people can afford these CVD drugs. So we intend to expand our research by conducting a survey at Karnataka, Andhra Pradesh, and few northern states also, if we get a proper funding, as it is a pilot project, we have received some 2 lakh rupee money. With that money only, we have identified these factors by comparing 10 private hospitals with 2 government hospitals who are offering this health and heart related diagnostic as well as treatment. So why I am discussing these things means there are many flexibilities are there under TRIPS agreement, but when it comes to technology sharing, still many private companies are holding these rights. But from the side of government of India also, they have taken certain initiatives. Very recently, they have included 2 drugs in this national list of essential medicines with regard to this CVD, known as Ramipril. So because of that only, this medicine is accessible to these 25% people. And during our observation also, there is a huge difference between affordability of the CBD medicines between rural as well as urban areas. So at rural areas, still these generic medicines are not accessible and affordable. And with regard to income levels also, the high income level people are in a position to afford, but still the low level income people are subjected to economic liabilities. And ultimately, there are certain important issues are also identified by us with regard to supply chain related issues. So, though we have certain important schemes like National Rural Health Mission, but these CBD kind of things, they're not taking up. Their focus is about malnutrition as well as communicable diseases. As the CBD falls under the category of non-communicable disease, still the governments are prioritizing when it comes to providing a grant for the purpose of treating uh, these medicines. And during our interaction with many people, what did they opined is, even though 1 or 2 medicines are available with Jana Aushadhi or generic drugstores, still they are apprehended that the branded drugs are good, their efficacy is more compared to the generic drugs. So there is a long journey to go. So we have conducted one sensitization program, but the level of understanding in these communities is very, very less. So like that, my dear friends, like my good friend, Professor Srinivasulu, I'm not expressing my opinion in a very rhetoric way. So my thought process is very much close to realistic school of thought. According to me, these CBD drugs still they're not accessible as well as affordable to communities who are there in the state of Tamil Nadu. So like that, it is the responsibility from the side of private companies also, after earning profits from their inventions after 20 years. So they should allow our Indian companies to develop the generic, but unfortunately, because of evergreening practices, very recently, before Delhi High Court also, with regard to type 2 diabetes drug, there is a dispute between American-based pharmaceutical company with regard to the generic version of the same type 2 diabetes drug, but ultimately the court has delivered the judgment in favor of citizens only. So like this, finally, what I intend to express through this webinar is that a balanced approach is the need of the hour. Whenever we talk about this balancing task, yeah, knowledge and innovation. The basic purpose of intellectual property rights is to promote uh, innovation, but at the cost of what? So when the people are not in a position to pay their diagnostic cost as well as treatment, and one way they're suffering a lot because of lack of affordability and accessibility. Still, we are talking about these IP rights and all. I can say finally with one thing in such a way that it is the responsibility uh, and duty from the side of multinational companies, especially the pharma companies. So if we read the articles from Lancet as well as Nature, all these drugs are owned by a patent family or a patent thicket. So as we are not having a global competition law, we are not in a position to question why a particular category of drugs are owned as well as manufactured by a particular family only. So with these few things, I thank Professor Benjamin from Mysore University for providing this wonderful opportunity to share a few important aspects on this day. Thank you.
Thank you so much, Professor Sudama, for such illuminating address. Now, we shall conclude our formal proceeding. I would like to request Ms. Sarah Benjamin to deliver a vote of thanks on behalf of the Department of Studies in Law and University of Mysore. Yes, Ms. Sarah, over to you.
Good evening to one and all present here. On behalf of the Department of Studies in Law, University of Mysore, it is my privilege and honor to propose the vote of thanks at the conclusion of this international webinar on intellectual property rights and public health in developing countries. At the very outset, I express our deepest gratitude to our chief patron, Professor Dr. Loknath N.K., Honorable Vice Chancellor of the University of Mysore, and to our patron, Srimati M.K. Savita, Registrar of the University of Mysore, for their constant encouragement, academic leadership, and unfailing support in making this webinar possible. We are profoundly thankful to our chief guest, Professor Dr. T. Ramakrishna, Professor of Law and former IPR Chair Professor, National Law School of India University, Bengaluru, for his enlightening address that offered great insights into the interface of intellectual property rights and public health challenges in developing countries. Our heartfelt appreciation goes to our guest of honor, Professor Dr. G.B. Reddy, Honorable Vice Chancellor, National University of Advanced Legal Studies, Kochi, for his thought-provoking reflections on how intellectual property intersects with access to healthcare. We extend our sincere thanks to our keynote and distinguished speakers, Professor Dr. Srinivasulu N.S., Professor of Law, National University of Juridical Sciences, Kolkata, Professor Dr. Sanjit Kumar Chakraborty, Professor of Law and Director, Center for Law and Social Justice, West Bengal National University of Juridical Sciences, and Professor Dr. P. Sri Sudha, Dean, SRM School of Law, Chennai, for their scholarly and insightful deliberations which enrich today's discourse. A special word of gratitude is due to our organizing secretary, Professor Dr. M.S. Benjamin, Dean, Faculty of Law, for his guidance and academic vision, and to our coordinator, Mr. Syed Kudrat Hashmi, PhD scholar, for his meticulous planning and dedication in coordinating this event. Finally, I would like to sincerely thank Mr. Millen who single-handedly managed the technical aspects of this international webinar. His commitment and behind-the-scenes efforts ensured that this virtual event was seamless and successful. To all our participants, distinguished guests, faculty members, students, and attendees from across India and abroad, we extend our heartfelt appreciation for your time, attention, and active involvement. Thank you once again and wishing everyone a pleasant evening ahead.
Thank you. Thank you, everyone. I wish you a pleasant evening. Thank you.